the item. Minutes or correspondence?
So moved.
Second.
All in favor?
Aye.
Passes on a 401 vote. Supervisor Thomas is on his way to Washington, D.C. with CCWD this morning. We'll stand in recess till 9:10.
That's the first time we've been through public comments in less than an hour and a half.
We haven't got
there yet.
Excuse me. That was a consent.
comments. 1, 2, 3, 4. I'm going to have to make an agenda change with item 4 because some of the staff members have to leave. So please indulge us with that. I would like to move to item 4, discussion and possible action, the claim refund for Mr. Roberts. Mr. Roberts has given us a letter. Mr. Roberts, are you here? Yes, Mr. Roberts, could you please come up, introduce yourself? This issue has been heard by, you can just go back there to that mic if that's easy for you, so we can hear you. Tom.
Two things. First,
Mr. Roberts, could you just introduce yourself, please?
surely. My name is Alan Roberts. I own the property at 1838 Pinecone Drive in Arnold.
Okay, did you want to stand there or did you want to sit here?
I have a little graphic. I made basically this.
Let me just, okay. Mr. Roberts, this is an appeal from the, what do we call it now?
Assessment Appeals.
The Assessment Appeals Board. It's our first appeal from the new Assessment Appeals Board. Mr. Roberts, you have 15 minutes to address the board.
Oh, I'm sorry. I wasn't told that before. In presenting this the other day at the Assessment Appeals Board, I found that, in fact, the timeline gets a bit complicated. And so I made what is a very unprofessional graphic here, and I apologize for that, but it helps clarify the timeline. The other thing I found, told this story many times, and unfortunately it has a lot of details, and it's a little difficult to tell it in 15 minutes. I apologize, but I wasn't told ahead of time that I had only 15.
We do have your letter.
Let me launch in.
Okay.
In 1996, the then owners of the property got an septic assessment and found that they couldn't build on it, they couldn't get septic approval, so they abandoned the property. They said, there's no point in paying taxes and paying for the CCWD water bond, the 1988 CCWD water bond, when I can't build on the property and I can't sell it. So they abandoned it. It was abandoned across the period from 96 to 2002. By 2002, the property was in arrears for 5 years, and so the county foreclosed and put it up for tax auction. It was bought at tax auction by Shane Crow. Shane Crow bought it for, I believe, about $1,200 at the tax auction. He believed that the CCWD water bond didn't survive that transaction, or that foreclosure. He was wrong about that. And the CCWD water bond that was $5,800 in 1988 had, through penalties and 10% interest and considerable legal fees, grown to over $20,000. Sherman Feller immediately approached Shane Crow, demanded payment of the $20,000. He threw up his hands and said, no way, no how. He immediately abandoned the property again, didn't make any tax payments, any CCWD water bond payments. And things went forward. Right at the end of 2004, December 2004, CCWD took it to court, got a judgment, because theirs had been in arrears since 1996, got a judgment, and in spring of that year, they put a posting on the property announcing that it was going to be auctioned in approximately November of 2005 because of the CCWD arrears. And the announcement, the posting said at that point, that was about $32,000 it had grown to. Considerable legal fees associated with the lawsuit and foreclosure. In point of fact, in the middle of 2005, early fall of 2005, I bought the adjacent property, 1868 Pinecone, immediately adjacent to 1838. All right, then the CCWD auction, for various reasons, got postponed. Didn't occur until, in fact, May of 2006. In May of 2006, we had grown to $42,000, and that was the minimum bid at that auction. There were no bidders at that auction. The property was generally understood to be unbuildable. If it had been buildable, it would have been worth $42,000 or more at that auction. There were no bidders. Meanwhile, across that time frame, in 2006, the new fire policies were coming into play, and Tim Bottomley, with Ebbets Pass Fire District, was getting increasingly aggressive about the enforcement of the fire policies, and he was in contact with Shane Crow, getting him up to maintain this property, which was a fire hazard. Shane Crow told him, "Oh no, since 2002, I turned that property back over to the county." Tim Bottomley contacted the county, and the county said, "No, it doesn't work that way. Yes, he owes us quite a bit in back taxes, but in point of fact, he's still the owner of record. He's still responsible for the property." The thing that occurred at that point is Tim got increasingly aggressive, sending him notices that he was going to incur fines if he didn't maintain the property. So Shane's in a pretty tough position. He owns a piece of property that has debts because CCWD water bond that far exceeds its value, and yet he's responsible for the property. So Shane got creative. What he did is he came here to San Andreas, and he filed a quit claim deed on the property over to Kathy Jones. Kathy L. Jones. Kathy L. Jones was an acquaintance of his who had loaned him money, and he had never repaid it. And so he filed a quit claim deed over to her. By that point in time, she was living in New Zealand, which he knew, because about a month later he told me that he was the one that told me she was in New Zealand, and I was trying to track her down. But when he filed that quit claim deed, he gave an address, a California address that was more than 2 years defunct. It was an invalid address, hadn't been a valid address for her for more than 2 years. So his whole point was dock responsibility, get Tim Bottomley off his back, which in fact he accomplished quite nicely. So at this point, August 2006, quit claim deed, he had just made Kathy Jones the new owner. He didn't inform her of that. She's in New Zealand, had absolutely no way of knowing that, but she's the new owner. Okay, a quit claim deed, that's a change of ownership. Change of ownership triggers what? A reassessment. The property was reassessed, and I don't know the precise date, but as I understand, I think it was sometime just into 2007. It was reassessed. It was reassessed at $115,000. Up to that point, the assessment was $6,485. Reassessed to $115,000. Now, so the announcement on that went out to that defunct address, and that started, which therefore it didn't get within 8,000 miles of Kathy Jones. And so at that point, that started a clock for her to make a timely protest of that, my words, rather absurd $115,000 valuation. 60 days came and went. Sure enough, Kathy Jones still didn't have any idea whatsoever. She owned the property, didn't have any idea it had been assessed at $115,000. And so after those 60 days, boom, it was etched in stone. In the context of the assessor's office, not appealable. Any appeal would be untimely from that point. So certainly that occurred, and forevermore, that $115,000 valuation in the tax period starting in August of 2006 was etched in stone. Okay, so time goes on. Basically, across 2007, not too much happened other than Sue Freeman and I had been trying diligently to locate Kathy Jones. Sue Freeman's in the tax office here, the tax collector's office. Sue, how am I doing time-wise here?
Yeah, about 7 minutes.
Halfway through this story.
I think you need to really focus on the one item that's before on the agenda.
Well, I think you have to understand the story and understand
Well, I'm just telling you, we do have your letter, which is giving us everything that you've discussed so far. So, that's your call, Mr. Roberts.
Okay, you with me on the letter? Am I
Yes.
just reiterating things that you don't need to hear? Because I don't want to waste your time.
We have read it.
It's your
thoroughly.
time.
Okay.
Yes.
So
And it was a great letter, well written.
I'm sorry.
It was a great letter, well written.
Thank you. Okay, I don't feel the need to reread that letter to you, but let me just, a couple of things that weren't in the letter, let me point out. So ultimately we locate Kathy Jones and she does some due diligence. Obviously skeptical about with my interest, without telling her the truth, that this piece of property is substantially worthless. And so she did due diligence with a realtor in Valley Springs. Ultimately, he basically apparently figured that all out, told her it was hopeless. I did the transaction with her and bought the property, paid her $1,000 plus $155 in back taxes she paid, plus $45 for FedEx and the quitclaim. At that point, then, she did a quitclaim over to me. So where are we? We're in April of 2008. The property is quitclaimed over to me from Kathy Jones. I immediately tried to protest this, again, in my words, absurd valuation, and was told I had no rights to do so because I wasn't the owner of record at the time. So I turned to Kathy Jones. Even though she had no vested interest at that point, she'd already quitclaimed to me. She agreed this just wasn't right, and she put in the request. There was immediately a reassessment. In that reassessment, I had information filed for that APN from my septic engineer to validate that the property was unbuildable. For some reason, that didn't get filed under the right APN. So when this first reassessment occurred, and the notice on it came out in June of 2008, it took the property valuation immediately from $115,000 to $60,000, cut it almost in half, with, as it turns out, absolutely no argument presented by the person requesting the review. When that occurred, the reassessment is applied back to the beginning date of that tax period, and now I'm the owner. $60,000 is half as ridiculous as $115,000, but it's an unbuildable lot, and so I've still found that the $60,000 was ridiculous. So I immediately put in a protest. We tracked down the engineering information, got it to the APN, and the reassessment occurred to $8,000, and that's the assessment on the property today. Okay, so I still was feeling, and when this reassessment occurred to $60,000, when I got the property, I paid $2,960 in taxes on the property. It was all back taxes, penalties, and interest to stop that whole vicious cycle of penalties and interest. When this reassessment occurred, I got a refund of $631 against that, and that's not in the letter. Got a refund of $631 against that, as that reassessment was applied back. And then when it was reassessed to $8,000, which occurred in August of that year, that was applied back only to my date of ownership, and I got another refund of $91. So at that point, about $700 of what I figured to be about $2,200 worth of overtaxation, if you will, had been refunded to me, and I was whole from my date of ownership forward. But for the period from August of 2006 to my date of ownership in April of 2008, There were still assessments for part of that period at $115,000, part of that period at $60,000 that I paid taxes on. I still felt this was completely wrong, and I started going after the assessor's office saying, hey, this doesn't make sense. She had absolutely no way to know. I was, in that time frame, put in touch with a nice lady in the tax office that pointed out Tax and Revenue Code 5096 to me. 5096, so I'm not appealing anything that happened at the Board of Equalization meeting. I'm appealing the Board of Supervisors, excuse me, under Tax and Revenue Code 5096 for the refund of those taxes. And I can give you the...
Mr. Roberts, you have about 2 minutes left.
When I looked at Tax and Revenue Code 5096, I went through it. It was one of those hallelujah moments because basically it said to me that, okay, there is logic in the world. The legislature has seen fit to provide a means for redress in a circumstance like this where she had absolutely no way of knowing that she was the owner. If you look at what's in bold, any taxes paid before or after delinquency. After delinquency says forget the etched in stone rule in the assessor's office. Any taxes paid before or after delinquency shall be refunded if they were paid on an assessment that was excessive, attributable to erroneous property information supplied by the SSE. Now, when Shane Crow came here to file that quitclaim deed, he gave 2 pieces of information: the name of the person he was making the new owner and the contact information, the address. Name was very valid name. She's a real person that exists. It wasn't fictitious. But the address was very invalid. It was very erroneous.
Okay.
Now, was that material? Yes, it was material because she was denied by the fact that she couldn't receive a notice. She had no way of knowing.
Okay. Mr. Roberts, all this was heard at the Board of Equalization. So what you're saying is the Board of Equalization may state an opinion. You're appealing this refund. What you're appealing is that you want the refund on those taxes, correct?
Based on 5096,
okay.
Which is nothing that the Board of Equalization.
Okay, all right.
It's not an appeal.
All right, thank you. Thank you. Are there any questions for Mr. Roberts from the Board? Steve?
Just a clarification to go to your back page. What you're asking for is a refund in total of $2,960.
No, not at all. No. Not at all. That $2,960 covered the 6485 valuations from 2002. I'm not protesting that at all. I've already gotten refunds of $631 over $700 of that. All I'm asking is that for this period from August of 2006 until April of 2008, when it was valued at $115 and $60, variously across that period, that valuation be changed to $64.85 because the lot is unbuildable, and I can back that statement, and I would be happy to do so with evidence that I have.
All right. Thank you, Mr. Roberts. Steve?
I have a couple of questions. The first has to do with the septic situation. I understand that it's a pie-shaped lot and that a standard septic on that kind of a lot, as well as the steepness of slope, prevents the normal septic system from being installed. Did you investigate the engineered septics and the cost of those?
Absolutely. At the meeting the other day, because the valuation, the assessment that I had on the property was $8,000, I thought the assessment office had agreed with me that it was unbuildable. That's the information I had filed, and they reassessed to $8,000. It's very surprised in the meeting the other day when Mr. Gomes brought forward the statement that the lot was buildable. And so, in point of fact, I contacted Ron Marvin last Friday after the meeting and asked him about this. And he didn't know at first what I was talking about. And then when he didn't recognize 1838 Pinecone, he didn't recognize the APN, I mentioned that it was in conjunction with the Board of Equalization, and Mr. Gomes would have contacted me. Oh, okay, sure, that would. We didn't talk about a specific piece of property. We talked in general about steep lots. So I said, did he show you the plat map? No. Did he talk to you about it being a pie-shaped piece of property that gets ever narrower as you go down where the septic field would have to be? No. Did he tell you that there's a seasonal drainage on the side of the property that forces a much larger setback from that drainage than just the normal 10 feet associated with the property? No. And I said, well, wouldn't those be material? He says, well, yeah, it might not fit. So what you need to do is get your septic engineer to draw out a diagram of this and see if it will fit. I said, well, didn't you tell Mr. Gomes that you'd never denied one of these? He said, well, we've never denied one that would fit. I guess I should have said that to him. Well, over the weekend, my septic engineer did just that and drew out a diagram of it. Let me find the thing here. Wrote a letter to the Board of Supervisors. Drew out a diagram of it and showed that to build a two-bedroom, 864 square foot mansion on this property, you'd need 250 feet of septic field space, and the most he could eke out was 140 feet, 110 short, so barely over half what is needed. What he's saying here in a very official letter, as a professional opinion from a licensed septic engineer in this county, that there's barely over half the space that's needed, it won't fit. Additionally, Dale Pilgrim had this same lot evaluated by Steve Buckley back in the time frame of the CCWD water bond, and this is a letter from Dale Pilgrim to the Homeowners Association Board of Pinebrook, indicating also that when he had that evaluation done, they considered the experimental drip septic, and that Steve Buckley gave him the opinion it would not fit on that lot because of the pie shape, because of the steepness, because of the
Was all this discussed with the Board of Equalization?
It was not at the Board of Equalization because I was surprised by all this being brought forward. Remember
but the letter from Mr. Pilgrim was discussed, was part of the
letter? No, it was not. I didn't have it at that time.
So Dale just gave you a letter this weekend?
He did.
Okay, thank you.
I do have further questions. And this is both for our council and for you as well. It would appear that you're asking for relief from decisions that were made under the ownership of Kathy Jones after the Shane Crow quitclaim. And I'm wondering whether it's your interpretation of Tax and Revenue Code 5096 that which is to protect from the kinds of errors that you've outlined, can bridge the two ownerships, or whether it is specific only to that time under which you have ownership. To me, that's pretty central, and it's probably
that's a question for Mr. Seary.
Well, I'm asking both parties so that I know.
I definitely believe so. It says any taxes paid before or after delinquency.
Okay. But the question is, my question is, do you have standing for Kathy Jones? Because that's the
I'll ask
ownership.
Mr. Series that question. Mr. Roberts, do you have anything else you want to present to the board on this that happened this weekend?
I believe that's just one clarification. The amount, the number of dollars because of the different tax years and supplementals and how penalties and or interest get applied, I have no ability to calculate that. But I believe that number is somewhere, after what I've already been refunded, that number now is somewhere between about $1,300 and $1,500 to the best of my knowledge.
Okay, thank you, Mr. Roberts. Mr. Series? Thank you.
Steve, to answer your question.
Could you identify yourself, please?
David Sirius, Assistant County Counsel. I was also the attorney for the board, for the Assessment Appeals Board. A couple of things for cleaning up of the record before I get to your question. There are several applications that are technically before you. Applications number 95 B and D were withdrawn. Therefore, they're not relevant here. They don't exist. The main application that you're hearing is application number 95A, which is the 2000 regular assessment. That's the assessment where the Assessment Appeals Board agreed with the assessor's valuation of $61,200. The reason that the board agreed with the assessor is set forth in the record, but the short version is that they didn't believe Mr. Roberts that it was unbuildable. The evidence presented before that board was that, in fact, it was a buildable lot. You couldn't do a lot of things with it, but you could build on it. So the record will set forth in that lower tribunal why they made their decision. The other appeals, 95C and E, that Assessment Appeals Board didn't have jurisdiction because he was late, and he admitted that he was late, but they allowed him to present his testimony in any event, and that board denied the applications because they were untimely. So again, I return to my point that the only issue before the board really is 95A, that 2000 regular assessment. And the board did not, Steve, the board did not rule on standing. They never asked us to rule on standing, but had they asked us to rule on standing, we would have said that he has no standing. I hope that answers your question.
It does.
Am I allowed to comment relative to that?
Just a moment. I'll get to you first. Does the board have any other questions for?
Well, David, when you say he has no standing, you're saying he has no standing on any, or no standing except for 39A or whatever it is?
Yes, except for A.
Okay. Well, let me ask you, David, come back. I have a couple of questions. I just sort of equity questions. I mean, the assessor basically has agreed that he was in error in the assessment of $115,000 and in error in the assessment of $60,000 because when he was given full information, he reduced the assessment to $8,000. Is that not an accurate statement? Obviously, it wasn't worth what was on the books.
I would rather have the assessor's attorney answer that question, Tom.
Okay.
Julie Moss-Lewis, Deputy County Counsel representing the assessor. And at the assessment appeals hearing, what the assessor explained was initially Mr. Roberts had evidence that his lot was unbuildable. And all we had was the evidence of his engineer. At the time, it was assessed for $60,000. So the assessor reduced it as if it were an unbuildable lot to $8,000 because they did not have time to do the full set of research. At the time the Assessment Appeals Board was heard last week, there had been more research done and there had been comparables presented to the Assessment Appeals Board. The comparables for similar lots were $80,000 to $90,000. And There is now evidence that was presented that the lot is in fact buildable if an engineered lot is used. We cannot go back and raise the assessment because it had already been reduced to $8,000. But the assessor's opinion of value at this point is that it is in fact more than $60,000.
Well, let me ask you some questions here. I mean, Julie, whoa. I have a really difficult time with that, given what's in the record. And that is that this thing went to a default sale, and one gentleman bought it for $1,200. And it sounds like that was probably the only bid there. It found out that there was a CCWD bond. CWD took it to sale for, I think the record says, $42,000, and there were no bids at all. Then the lady that received the quitclaim deed basically has it independently verified by her person that it is an unbuildable lot, and then this gentleman buys it for $1,000. I mean, that is what's in the record. It seems to me it's awfully hard. And then the assessor basically reduces the valuation to $8,000, and now you're saying, oh no, it's worth $60,000. I mean, this thing is sort of all over the map here, and there isn't anything I can see that supports a $60,000 valuation, given what's in the record.
Well, first of all, Ms. Jones did not herself get an engineer to find that it wasn't worth anything. She was told it wasn't worth anything by Mr. Roberts and his engineer, at which point he paid for the property. And as far as the specific, if the board wishes to rehear the valuation issue, we could have the appraiser explain why it's worth $60,000. I know under 5097, the one thing that the Board of Supervisors does not have jurisdiction to do at a claim for refund is to reevaluate the property. There is actually law that says that is the exclusive jurisdiction of the Assessment Appeals Board. So,
you're the one that introduced the $60,000 figure.
Maybe Steve.
You think it's worth today? I mean, what's in the record for us is basically the last action was a reduction by the assessor of the assessment to $8,000.
I think she's just reporting on opinions of the assessor. The lawyers in my office aren't experts on value. I think it's
so I think that's what before the board, and that's what we need to judge our.
I mean, to clarify, at the Assessment Appeals Board, there was a discussion of valuation and evidence presented, and the determination by the time we met last week was that the property was worth $60,000, and that was after a hearing on the evidence. So.
Okay. Thank you.
Just a moment, Julie.
Sure.
Steve, did you have questions?
I have further ones, but I'll go ahead. I know others have as well, and maybe we can get to. I guess before we move, it's absolute that there is no standing for that period between the two quit claims. That's the position of our counsel here.
Well, yeah. I can say that for the purposes of filing an appeal, there was no standing. There was absolutely no jurisdiction for the Assessment Appeals Board to hear.
But that's not what the person here is arguing. And so I'm trying to reconcile exactly what is before us before we try to figure out the criteria by which we judge it.
And one thing I would like to add that was discussed at the Assessment Appeals Board to set the record straight, in 2007, as Mr. Roberts admits, he told Kathy Jones, hey, you own a piece of property, and there's this high assessment on the property. At that point, she had time. She knew and she had time that she could have, whether it was through Mr. Roberts, who was clearly interested in the property, or what have you, filed an appeal. And if you look at Mr. Roberts' letter, All right, he says, well, she was busy with her son's Crohn's disease. There was a number of reasons that he's putting forth for Kathy Jones of why she didn't bring that appeal.
But isn't it also true that the county sent to a wrong address the notice that somebody would have the right to appeal and all of the adjustments that were being made on the property between the two quitclaims? And at what's the level of responsibility if there is information that was sent that was wrong, and maybe intentionally so by the original
Well, the position
party?
that we took on that issue at the Assessment Appeals Board is even if it were true that there was some defect in notice, first of all, we did address the issue that Mr. Roberts did not have standing to bring forward Kathy Jones' argument.
Right.
Part of his purchase price agreement with her was to pay the back taxes. So the other point is, though, that Ms. Jones, even if that notice defect hadn't existed, she still, by the time she learned of the property, there was still time for her to file an appeal, and she chose not to. So even without the notice problem, it would not have been timely, so there was no jurisdiction whatsoever to hear. You know, we had a hearing on timeliness only at the Assessment Appeals Board.
Okay. Any more?
Yeah, I'm done.
During the time period that he owns the property, there was a reassessment and he was giving a refund for back taxes.
That's
Is that
correct. Yes.
So there's no argument there because he testified that he's not arguing that point. He's arguing the point of the timeline when she owned the property and the valuation of that time period.
That's correct.
And he wants, so any time afterwards, he's in agreement to that refund that you gave him in the assessed value. So he's in agreement that $8,000 assessed value to him, not the $1,000 that he bought. He's in agreement of that assessed value, even though they're testifying that they feel now it's worth more. Is that correct?
That's correct.
Yeah.
Okay. Any other further questions? Okay. Do you have any questions of the assessor? Steve? Gary? Okay, thank you. Mr. Roberts, did you want to make a comment? Short?
I will try. It was presented there as if I am appealing the decisions of the Assessment Appeals Board to you, and I am not.
No,
I accept the untimeliness. I accept the etched-in-stone rule. I'm appealing to you under 5096, which they have no jurisdiction over. It wasn't a part of the Assessment Appeals Board, and the words of it seem very clear. Any taxes paid before or after delinquency shall be refunded if they were, etc. Any taxes paid before or after delinquency. I paid those taxes after delinquency, after untimely periods, and all of that. And the other things applied. I think I established that pretty carefully with you. And so I don't believe there's a jurisdictional issue. Any taxes paid, I paid them after delinquency. And yes, those taxes were assessed during Kathy Jones' ownership, but I paid them, and under 5096, I have a right to request a refund of them.
Okay, thank you, Mr. Roberts.
I believe that's very clear.
Thank you. Do you have any further questions of staff? Okay. The question before us is, should Mr. Roberts be repaid for the taxes during that time under 95A? And
Excuse me, not under 95A. It doesn't relate to 95A.
that's the comparable. We're talking about the untimeliness. That's what was before us. Is that my understanding, Counselor?
We disagree with Mr. Roberts' characterization of Revenue and Taxation Code 5096. You can't read it independently from the Assessment Appeals Board. He went to the Assessment Appeals Board. That was a preliminary step. To the extent that the Assessment Appeals Board made a decision. It'd be one thing if he didn't go to the Assessment Appeals Board, but he did. Having gone to the Assessment Appeals Board, you now have a decision. And so you simply look at 5096, you look at the criteria, did he meet any of the legal criteria? Did the Assessment Appeals Board make some kind of error, or is there some error in the admission of evidence? If not, our position is that the appeal is denied.
Would he have had the option to go completely around the Assessment Appeals Board and bring this to us under 5096 directly? And if that's the case, why wouldn't he also have the ability to do two separate approaches in each of the venues?
You could designate the appeal, the assessment appeal, as a claim for refund. You could do that. Sometimes taxpayers do that. That wasn't the case here.
May I respond?
You have 1 minute.
I wrote a letter in June, asked to be on your agenda for the July meeting. I was on the agenda, and then the recommendation leading up to that was that you had to deny because I had not exhausted my options through the Assessment Appeals Board. So I said, okay, fine. I went to the Assessment Appeals Board, and then I got on the agenda for here. Again, lost my train of thought. I apologize. But if you look at 5096, cover to cover, I read it. It says absolutely nothing about the Assessment Appeals Board or any decision of the Assessment Appeals Board or anything else. It has very plain words. Any taxes paid before or after delinquency shall be refunded if.
Okay, thank you, Mr. Roberts.
I just want to read you a case this is a court case called Little versus County of Los Angeles. The Assessment Appeals Board process is essential to filing a subsequent claim for refund. Skipping this step will usually result in dismissal. You have to exhaust your remedies. And so what we're saying is it doesn't matter. It doesn't matter whether he skipped the step and we overlooked it. We didn't skip the step here. You just look at the criteria under 5096. If the criteria isn't met, there's no error in the record, then the decision should be upheld.
Okay. Thank you.
David, just a quick question. Did the appeals board entertain the arguments on 5096 and reject them, or did they just not address the issues under 5096?
The appeals board doesn't have jurisdiction over 5096.
Exactly.
Okay, well then it is appropriate that it be here.
Okay.
The only place for it to be.
All right. And, okay, I want to, the comment period, bring it back to the board for a decision. Board members?
Well, for my vote, I'm going to vote to allow the refund to the extent the law allows. And I'm not quite sure what the extent the law allows, so I'll leave that to council. But I think quite clearly, given what's in the record, that the property was not only significantly overassessed, but there was some sort of shenanigans, enough shenanigans involved that responsible people really weren't given much of an option to act responsibly. I mean, if I were living in New Zealand and received something in the mail from the assessor saying that I had just been quit claim to deed of a property worth $115,000, I'd be pretty ecstatic about that. And quite frankly, I don't think my first reaction would be as, oh, I'm going to appeal this. I don't even know the property. I mean, I would be thinking, man, I just had a significant windfall. My first reaction wouldn't be to appeal it. So it takes time to work out what the evaluations are, and I think it's quite clear when the assessor bought in to at least the argument, and maybe even a little bit of the equity of the argument, when they reduced it from 115 to 60, and then further reduced it from 16 to 8. And so I think within what the law allows, I'm willing to grant the appeal.
Is there a second for that? Motion dies.
For purposes of discussion, I'll second it. I do think we need to figure out something here.
Pete, I don't think this is an adversarial process. I don't think that you can leave it up to council to determine the amount of the refund. I don't think that would be fair to either side. It has to be based on some evidence.
It's got to be a
I understood it would make a claim for an amount, but I'm not sure if I kept up with the math.
Well, what would be the action that would be appropriate for the board?
Well, I think he needs to articulate what the refund is requesting is, and then take some evidence on it.
Well, according to his testimony, he wasn't able to calculate it.
Well, we can give an approximate.
Said between $1,300 and $1,500.
But that was a dollar amount. That's not the basis of the claim. That's the result of the claim.
Basis is the $8,000.
It may have been brief. I'd be happy to restate it.
Please restate it.
I said that between August of 2006, when it became Kathy Jones, and April of 2008, when it became mine, it was variously assessed at 115 and or 60.
Okay, then
and that I felt the appropriate valuation was a continuation of the 6485 that was on the billable lot. And so what I was requesting was to be refunded the difference between what the taxes would have been at 6485, which I'm perfectly willing to pay, and what they were at.
I understand. If what I'm making is a motion and not comments, then I will incorporate that in my motion.
All right. And I'll maintain that second with a few comments. It seems to me there's sort of a logical conclusion that is completely elusive to us all in this, and maybe outside of our scope. But if you're looking for what the worth of a property over there is, and you have comps at 60 to 90,000 or 80 to 90, I think we heard at one point from the assessor. Then the question is, what were those comps? And in this case, the comps were buildable lots with a standard septic. This lot clearly is not buildable with the standard septic, but may, and there's some confusion about this, be buildable with an engineered septic. The cost of an engineered septic is considerably greater than a standard septic, and so there is a mathematical equation that makes sense to me, which is that you'd take the comps of a buildable lot, you would subtract from it the amount that it would cost for an engineered septic minus the amount that you'd spend anyway for a standard septic, and have some idea of the relative valuation to the other properties. I know we're not supposed to even be talking about the valuation, but to me it gets back to what's fair.
The comps were also engineered septic lots. I just wanted to make that clear.
All right, well, that's the first that we have heard that, because what's before us is something quite different. I don't know whether that comes into this because you've closed the input, but at any rate, that would make a difference, or would have made a difference if it came in. What I've got in front of me is a statement that they were all buildable lots.
Right, because we didn't expect that we would be revisiting the issue of valuation at this particular time.
All right. Well, at any rate, there's enough misinformation that was provided to county staff that acted in good faith based on that information that there appeared to be lots of room for trying to get something right in this after so much error. And so I believe that small adjustment makes sense. It's not a huge difference between the parties, but it does create at least some consistency during that period between quit claims.
Well, I take the county council's word that he has no claim. The owner, he testified that he contacted her in 2007. We've had testimony that she had that time frame fits for her to appeal the amount back then. I think when he bought the property, he knew he owed the back taxes. He was refunded the difference from when he owned the property, when he took the property possession and title to it. He cleared the title through those back taxes, knowing full well that those are what were owed. He didn't own the property at that time, so I'm not in favor.
Okay.
This appeal.
Okay, I agree with Supervisor Tuffanelli. Pretty much said what I wanted to. We have a motion, we have a second. Any further discussion? All in favor?
Aye.
Opposed?
No.
No. The assessment appeals is denied. When you have a 2-2.
That's correct.
And so it is
The
denied.
request for refund is denied.
Thank you. All right, I'd like to move back to public comments. Thank you all for waiting. Anyone who has a comment they'd like to make that is an item not on the agenda, please come forward.
My name is Michael Bottoni, and I'll probably jack up here, but I would like to know how much
Excuse me.
did this cost us to save $1,300? You guys have any idea how much you just spent to deny a $1,300 claim? Yes? No?
Mr. Matton, everyone has the right to an audience on an issue before the board, just as you do. Is there...
I'm asking, how much did this county just spend to deny a $1,300 claim that's somewhat nebulous as to whether it's good or not?
Well, that was a decision the board made. If there's a comment that you'd like to make on an item not on the agenda, please do so.
I just did.
Okay, thank you. We
I asked
thank
you a
for your
question and you
comment.
couldn't answer it. Thank you.
Thank
I'll be
you
back
for your
up for the next
comment.
question. Thank you.
Does anyone else have an item they'd like to address on an item not on the agenda?
Good morning. My name's Bonnie Newman. I'm from Double Springs. I just have two updates. Bring you up to date on issues I brought before the board before. The Double Springs Lodi Express still leaves daily from Double Springs at 7 a.m. and 2 p.m. Anybody needing a ride out of the county from Double Springs is welcome. I lost my rider to Stockton, so we have 2 empty seats. That means, of course, twice a day I also return from Lodi at 9 a.m. and 3 p.m. So that unsubsidized transportation is still available to anybody that needs to get to that side of the county. The other thing is I've mentioned a couple of times wondering what happened to Gary Kuntz. I've also received phone calls at home from people that I don't know asking me, did you find out what happened to Gary Kuntz? And last week somebody slipped me a note and said, if you want to find out what happened to Gary Kuntz, show up at the town hall on Thursday at 6 p.m. And so I did, and I found him. He was there. He's decided to run for sheriff. So those 2 ladies that called me, I think if we want to see Calaveras' favorite sheriff again, we've got to vote him back into office. I don't know what came first, the chicken or the egg. Did Gary get canned and then decide to run for sheriff? Or did he decide to run for sheriff and then get canned? The sheriff wants to tell me what happened to Gary Kuntz, but we haven't been able to meet. So I'm still waiting for my appointment with Mike Walker. And when he explains to me, then I'll come back and explain again, because I think this is the forum that we need the explanation of what happened to Gary Kuntz.
Ms. Newman, we will not be discussing personnel actions in the boardroom.
Pardon?
So we will not be discussing as a board any personnel actions in any department in this boardroom. You can choose to make comments. The board will not.
Oh, so if I ask, like, the question, and I'm expecting the answer really to come from the Sheriff's Department, I'm really not asking you all, but I just felt
Thank you.
that...
I just wanted to clarify that for the record.
Okay, thank you. And I would still like to hear in this forum from the people that made the presentation that Gary Kuntz was not going to be a sheriff anymore, how that came to be.
Okay.
Thank you.
Thank you, Ms. Newman. Does anyone else have an item they would like to discuss not on the record, on the agenda? Yes, please.
I'm Polly Sender, and I'm from Mountain Ranch. I'm here because the county has chosen to increase our speed limit in town from 35 to 45 miles an hour, and I think this is a terrible situation, a terrible decision. They told me that they had made a study and that the people were actually going through town at 45 miles an hour, so they needed to increase the speed limit to how fast the people were going. In my opinion, when people are disobeying the law, we have rules and regulations, and we should take care of it through those means, not increase the speed limit. Now that the speed limit is 45, if what they just told me about their study is true, pretty soon it'll be 55 in town. And I really think that the Board of Supervisors or someone needs to control the Department of Public Works to the extent that they fix this. No one in Mountain Ranch complained about the speed limit being 35. No one complained at all. And they changed it. And right at the edge of town where there's a bike path and a crosswalk, it goes from 45 to 55. This makes no sense to me, and it would look like you're looking for a tragedy in Mountain Ranch. The children cross the road in crosswalks by the ballpark. If people are coming down that hill at 45 miles an hour and children are crossing the road to go to a soccer game, a person can't stop. I mean, I've stopped at that crosswalk in the past for kids crossing, and people come down behind me and I feel like they're going to hit me. But there are crosswalks in our town, and I think you have an obligation to remove those crosswalks if you're going to maintain a 45-mile-an-hour speed limit, because we teach children all the time that you stop and look and listen before you cross the road. But when there's a crosswalk, you're safe. Well, in Mountain Ranch at 45 miles an hour, you're not safe, because the cars are coming too fast, especially if you have a little child that's 3 years old or 4 years old and trying to push their tricycle across the street to get to the bike path. The bike path actually crosses at a crosswalk in town. We're just looking for a terrible tragedy in Mountain Ranch with an increase like this. At the same time that you increase this one to 45, and I say you because it's the county that puts the signs up, you decreased the speed limit here in San Andreas. You moved your 25-mile-an-hour limit out a little ways, and it's 200, well, I don't know, maybe not 200 yards maybe, but, you know, you've moved it out of town a little ways. So please come back to Mountain Ranch and put those 35-mile-an-hour speed limit signs up, because this is really not fair to the people who live there. You have roads that come out and they stop at Mountain Ranch Road. You have to turn to the right or left. You can't cross. And if you pull out into that road, the people who are coming down the road at 45, and now I think it'll be 50 or 55, they're going to hit you. And I've seen accidents in Mountain Ranch. We've had terrible situations where people were going too fast. And I know that one of the reasons they studied our town or studied our area was because of the terrible accident on March 1st of 2009. And those young people were killed on Mountain Ranch Road. And I know you studied our whole road. It's 9 miles. And this is just a terrible unintended consequence, in my opinion, because people came to you requesting that the speed limit be lowered. and in the end you come to our town and increase the speed limit? This makes no sense to me. This is such a dangerous, dangerous situation. I know we no longer have the school in town, but we do have a ball field, and the children cross the road, the people cross the road. We have soccer games, we have baseball. I just think that you're looking at a situation where the county will be involved in lawsuits, where it's just not, it's not smart to put yourself in a place where you're going to create problems. If you don't create problems, you don't have to solve them. But I think that someone here at a county level needs to make a decision to help the Public Works Department. If we need to go to the state of California and tell them that their rules are wrong, then we need to go there. I think just because someone makes a wrong decision doesn't make, it doesn't, I don't know. I just think that this is an unintended consequence of someone trying to fix speed limits that were too fast and dangerous. We just have a lot of...
Supervisor Walensky's very familiar with this. He's going to be working with Public Works and the community on this.
Well, I would like to say a thing or two on this. Polly has, with great articulation and calm tone of voice, expressed the same sentiment that many people who lack those two qualities have spent on the phone with me for the last week since this occurred. I've been flooded with calls with people who are with greater decibel and more crude articulation. What I think is important right now, because we have been working now for 2 years since the early meetings where Mountain Ranch, we had 200 people in a room saying that their biggest public safety concern in Mountain Ranch was the road. And we have actually got grants and money to do repairs. Even those have become controversial, but I think it's high time that we had a community meeting with Public Works and recalibrated our whole approach. I don't know whether these unintended consequences are the only option that we have. I sure hope not, because,
I hope not,
because
too.
what you say is quite true. This is a town. It has an identity. It is bisected by a road that people from out of town go through at rather high speeds, and every time we've tried to do the metrics on this road is told us a couple of things. One is that most people, 85% of the people, are driving at what I think are unsafe speeds, and yet we have the California Safe Driving law that says you can only post enforceable speed limits at the 85th percentile. So I guess there are some strategic decisions that have to be made. It doesn't say we have to post the stuff.
I've lived in Mountain Ranch a long time, and I would say that we were safer. I believe we were safer with no speed limits posted on our road. I feel like people see a 55-mile-an-hour speed limit, and they've got to go that fast. They're looking at their speedometer, and they're trying to go that fast. So sometimes we make decisions where we think we're helping a situation, but we make it worse.
Well, and rather than, I when I was 7 years old, once stepped into some quicksand, and I'm familiar with the syndrome. Sometimes the more you struggle, the deeper you sink. What I'm interested in is stopping this cycle, because I don't think we've got it right yet, and I do want the community to be able to have full input and decent direct feedback from people who make these decisions and from the engineers that figure road stuff out. But we need a greater level of safety, not a lesser level of safety. This was identified 2 years ago as a top priority in the community, and what I would propose, and I hope this is okay with the director, that we schedule forthwith a meeting at the community hall to try to develop an agreeable strategy to make that road safer and to deal with speed limits in a way that both satisfies legal obligation and community will. I wonder whether the Public Works Director can comment on that invitation.
Thank you.
Tom Garcia, Director of Public Works. I appreciate the comments and the articulation of the concerns. You were dead on in the constraints that we have in Public Works in applying the California Vehicle Code and traffic codes with the 85th percentile. We can't write tickets for, or we can't have the Sheriff's Department enforce an unenforceable speed limit, and that's how, through the speed surveys, that's how the speed limits came about. Given that, I've also directed staff, based on the numerous calls with concerns of the speed limits, to take a look at the Mountain Ranch segment once again to see if there's any leeway that we might have, as there was in San Andreas, for revisiting the speed limits. And so we're doing that in-house right now. We would be glad to set up a public meeting in Mountain Ranch and go over our findings at that time. I'll be glad to work through Supervisor Walensky to set up a public meeting.
Okay, let's aim for sometime in November, and I'll work with Polly and others to arrange that.
Thank you.
Thank you, sir.
Mr. Garcia, we had the same thing on Avery's Sheep Ranch Road, and we made some adjustments. Okay, thank you. Does anyone else?
I make one other comment.
Yes.
I would really hope that this isn't just a series of meetings. I would really hope that there's a sincere effort to decrease this speed limit. And I'd rather not come back to you with a tragedy. I'm serious when I tell you those children cross the street, those crosswalks. Children feel safe in a crosswalk. Come to Mountain Ranch and take the crosswalks out of there. Get the bike path out of there if you don't want to have the children there. I just really feel this is such a dangerous situation, and we've made it much more dangerous. Thank you.
Thank you.
Just as a response, I actually did drive through Mountain Ranch after the comments were brought up to us, and I do have some concerns on the posted speed limit. So again, I have directed staff to look again at what our options are, but again, in applying the California Vehicle Code and California traffic standards, we do have to establish defensible speeds, but we are going to work with the residents and the supervisor to make sure that we take what leeway we can.
Thank you, Mr. Garcia.
Good morning. My name is George Fry. I came here in October of 1977, and I lived just outside of Mountain Ranch. And I hadn't seen Polly in years because I only lived there for about a year, and then I moved to Hathaway Pines. But I'm glad to hear what you have to say, Polly, and it's good to see you again. And Steve, I hope you make her the chair, because something will get done if you make Polly the chair. Thank you.
Thank you, Mr. Fry. Are there any other comments? Items not on the agenda.
My name's Terry Baker, and I wore my costume today because you wouldn't be here tomorrow. And I'm here to talk about the big cock problem that we have out in Railroad Flat. But before we do that, I'd like to talk about I would like to make public the public inspection request that we gave in March of this year, and we have yet to be able to get any information from the Sheriff's Department, from Animal Control. We have asked over and over again. They have to give us this information. I don't know what else I can do to get the information. Every time I go to somebody and ask them, they intimidate us, and they tell us that it's privileged information. Well, I'm privileged. As long as it's not confidential, hey, I'm privileged. So when I leave here, I'm going to go over to Animal Control, and I'm going to ask for the file on Roberta Redmond and the file on David Redmond. Roberta Redmond has been convicted and sentenced. David Redmond was acquitted. Now, we would like to get those files because it's public information, and there's no reason for you to hide it from us. You know, the Sheriff's Department has falsified our documents. The courts have backfiled documents. The district attorney has wrote fraudulent letters. David Sirius, I wish he was still here, but he left. He's writing us letters telling we can't get this information, and it's public information. It's a public nuisance that Mrs. Redmond was convicted on. And all we're trying to do is get a public nuisance that has been convicted to get it enforced. It's been going on for 4 years. And all we're asking is for somebody to do their job. What's so hard about that? We're not the bad people. We're the victims. Please tell me how I can get this information.
Okay. Did you identify yourself for the record, please? We know who you are, but let the record show.
Terry Baker.
Thank you, Mr. Baker.
Could you tell me how to get the information?
Mr. Baker, time to make comments. You've made them. Mr. Walensky is very much aware of that. You need to do what it is you think you need to do, please. This is not the time for the board to respond.
Okay, well, I'm going to make a plea to Sheriff Downham to please stop intimidating me. Please do not, when I go in to find out about my zoning, Sheriff, don't show up and stand next to me. When I go in to the courthouse to file documents, don't send somebody to stand next to me to hurry me out of there. When I go to the animal control, when I leave here, please don't intimidate me as if I don't have any rights to look at these records. They tell me, first they told me they were at the county council, and then county council told me they were at the DA, and the DA told me they were back at county council.
Thank you,
and then I went back to animal control, and they said, well...
Thank you.
Thank you.
Does anyone else have any comments they'd like to make that are not on the agenda? Okay.
So did I burn up a minute? This is Michael Battoni. Did I burn up a minute last time, or is it 5 minutes on each individual topic?
Mr. Mattoni, please, you'll have 5 minutes to address the board on any subject that is not on the agenda.
Okay. Good. Well, I've come before this board today to share some information I recently received from the county council's office through my supervisor, Gary Toffanelli, concerning code compliance in this county. In a nutshell, the codes don't matter, because as Gary stated in his reply, after talking with county council on your questions, it is their opinion that your neighbors are following the intent of the law.
That was their opinion.
I'm not denying their opinion, that they're following the intent of the law. I'm kind of a law and order guy, and I expect each of us to have equal protection and opportunity under the law. This mystical peering into the mind of scofflaws by counsel and discerning their intent to follow the codes is good enough is ludicrous and poisonous. Over the last 9 years, I've watched my neighbors run businesses from their property for which they were not properly zoned to operate and or for which they did not meet the requirements of the code to operate. I dutifully filed code compliance complaints for the over 2 years that they were not in compliance with the zoning codes, and was told by code compliance nothing was wrong, and eventually told to mind my own business. Interesting choice of words, as I was minding my own business. Eventually, they did seek a zoning change and were granted a conditional use permit to perform the exact same business they had been doing for the previous years. One would think the problem would be resolved. Alas, things were not to be. Within the A1 zone they now reside in, one of the permitted uses is an agricultural homestay. And there's the rub. County code is specific in its description of what standards were to be met to be an agricultural homestay. County code does not mention intent to meet. It says standards will be met. These standards are delineated in 17-16-060 performance standards. Number 6, agricultural homestay, subject to all of the following requirements. And I will be happy to stipulate that in the best of my knowledge, items A through E and H have been met. But since the agricultural homestay performance standards are subject to all of the requirements in item 6, let's focus on F and G. You should be pretty much aware of this. You own an agricultural homestay, don't you?
Please, Mr. Mattoni.
The agricultural homestay, item F, the agricultural homestay establishment is located on and is a part of a farm as defined in section 5226.2 of the Food and Agricultural Code that produces agricultural products as its primary source of income. In my neighbor's own words, this is what constitutes the J. Bar K Ranch. They have a private ranch setting, covered lighting area with fans, all-weather arena, 150-foot diameter, 50-foot round pen, half-covered 24 by 24 pens, stalls for horses, pastures, working cattle pens, natural trail course, obstacles for training, tack rooms for guests and boarders, large trailer turnaround. This is not an agricultural operation. This is a recreational activity. It's an equestrian training facility. That is not an agricultural operation. And as an aside, they do say, because we're a small hands-on operation, we raised only a few select steers for beef at this time. That is not their primary source of income, and they even admit it. And that totally fails the requirement of that being their primary source of income. Item G, the primary purpose of the homestay establishment is the guest education and active participation in the on-site agricultural activities. What are they doing for that? They start working their horses. Don't worry about what you need to work on your horse before you come to J-Bar-K Equestrian Ranch Retreat. That agricultural operation, the J-Bar-K Equestrian Ranch Retreat. If you have things you're working on or would like to work on or towards, feel free to let us know ahead of time or when you arrive and get settled in. They don't even make an attempt to say their guest education and activities are concerned with their meager few select steers, as the code requires. It's all about equestrian training, a non-agricultural operation. As for council's benefit, getting a conditional use permit is not one of the requirements for running an agricultural homestay. So the fact that it was mentioned in their conditional use permit is superfluous information and a disingenuous attempt to cloud the issue. I provided Gary with concrete evidence that my neighbors were running two openly and heavily advertised businesses, equestrian ranch stays and equestrian ranch retreats, for which they are not zoned or licensed to operate. This is the same information I have over years provided to my two previous supervisors and numerous rocks sitting in the code compliance offices. Council reviewed the information and, being unable to say they were following the law, as it is obvious they are not, tried to deflect the issue and say they were following the intent of the law. If intent is a standard by which compliance with the codes is what the Hagans, my neighbors, are held to, then it is the same for me, and I can do anything I damn well please on my property, as long as my intent is to follow the code. If the Hagans are only held to an intent standard for code compliance, then so should the Nemes. There's an interesting name. So should anyone in this county. The Hagans are not better than the rest of us, or are they? You tell us. Hiding behind this intent charade is nothing more than an effort to continue this business as usual, cesspool of favoritism, cronyism, and while not directly paid for play, definitely you scratch my back, I'll cover yours way of doing business in this county. Enough is enough. What is good for the rats is good for the people. Everyone needs to be made aware that in Calaveras County, intentions trump code. If, heaven forbid, one of the code compliance rocks rolls into your yard, all you need to do to send them packing is to profess your intentions to follow the code per county council. Let me state that again. The Calaveras County Code means nothing. As county council has stated, intentions mean everything.
Thank you, Mr. Mattoni.
Oh, you're welcome. You guys have a nice day.
We will.
I'm sure.
Does anyone else have anything they'd like to address to the board? Mr. Baker, is this on a different subject?
No, but it's only going to take 10 seconds. Next week, I'm going to come back and let you know what happened at animal control and getting these files.
We welcome that. Does anyone else have any other item they'd like to address before the board not on the agenda? I'd like to move to item 5.
Good morning, Mary Mutz, Agricultural Commissioner. I request that item 5, which I am establishing an agricultural preserve and authorizing a California land conservation contract with the Marion J. Sanguinetti Cattle Company, be pulled today. I have had further contact with the family, and they would like to study the implications, restrictions of a Williamson Act contract more deeply, and they have requested that I pull the agenda item.
Okay, let item 5 be pulled, and we'll bring it back when the applicants ready. Item 6.
Hi, Dave Pastizo, County Planning Department. I'm bringing before you an ordinance to change some zoning for some agricultural preserves. Some contract changes were made, and at this time we just have some contracts or some parcels going into contract that weren't before, so we need to change their zoning to AP. There's nothing coming out of Williamson Act contract this year, so that's not really an issue.
It's just to change the zoning.
Just to change the zoning, that's all we're doing. You did get an updated packet last night, and it should be what you have in front of you. There was just one parcel that needed to be added into contract 299. Let's see, the only other thing I'd want to state just for the record is the planning department does this once a year. We didn't do it in 2000 for contracts you approved in 2007 because even though there were some changes, there was no change in zoning required because contracts closed but then were reopened. Things moved around, but we didn't need to make any zoning changes, so there was nothing brought to the Planning Commission or the board.
Okay. Are there any questions of Mr. Pazzi?
I just have one. This seems like such a ministerial act. We've already taken our position on the Williamson Act contracts, and as I understand it, we finally are trying to make our zone consistent with that. Is there any reason why we couldn't develop a protocol in which you simply, based on the board's decisions about Williamson Act designations, make these changes without having to come back? Seems like it would be an efficiency move.
I'm not really sure. What I do know is that we need to do the ordinance, and that takes a board action. And so I'm not sure if we could, at the same time you approve the contracts, have the ordinance ready. That's something
it would be nice to just do it once.
The other thing is that, at least historically, what the planning department's done is wait until all the changes that get sorted out for a year are done, and then we just do them all at once, as opposed to doing them as they come all year long.
We've gone back and forth. We've done it both ways. It's whichever way staff would like to do it. The problem had always been they were always coming in one pack in December, but I think the board's open to whatever way is easiest for staff. Of course, easiest for us.
If there are no other questions or comments, I'll make the motion to approve the ordinance.
I'll second.
Any comments? Any comments from the public? Call for the question. All in favor?
Aye.
Opposed? Passes on a 401 vote. Thank you. Thank you, Dave. I'd like to move to item 7.
Dennis Gollums, Planning Department. Mr. Robert Wilson has applied for a zoning amendment, and this is in conjunction with the boundary line adjustment that he applied for. He reconfigured a 2-acre parcel, and in the process, he acquired about an inch, 1.25 acres of property that was, I know,
not bad,
it's an inch on the map. Contractor talking here. 1.25 acres of property that was zoned rural residential, and the remaining 3/4 of an acre continued unclassified. And as part of the condition of approval for the boundary line adjustment, he was required to rezone to bring the entire property up to a consistent zoning without split zoning, and that was one of the conditions of approval for recording the boundary line adjustment.
Okay, are there any questions from the board? Are there any public comments on this?
I was under the impression that everything unclassified was already changed.
No, that's not a true statement.
That was in a 24 square mile area that had been judged to not be consistent with our legal obligations.
I'm sorry, I kept thinking he meant countywide.
Yeah, that was
for that
piece.
area. Okay, thank you. Any other comments? May I have a motion?
Madam Chair, I would move that the Board adopt an ordinance to approve zoning amendment 2007-05 to change the existing zoning on parcel 56007-010 from U, unclassified, to RR, rural residential.
Second.
All in favor?
Aye.
Opposed? Passes on a 4-0-1 vote. Thank you. I'd like to move to item 8.
I think we should kill this. He said I could bust this in here so he can bring it back.
Good morning. Gina Cathan, County Planning. Just a brief history. The Copperopolis Fire District has been in the current location since 1973. In the year 2000, the district received a conditional use permit by the Planning Commission to conduct a helipad on the subject site. At the time, the existing district was considered to be a legal non-conforming use. The zoning amendment and the use permit will not only permit the expansion of the district facilities, but it will also create consistency between the zoning and the current uses. I also received an inquiry. There seems to be a little bit of confusion in the conditions on resolution for the conditional use permit. That would be page 2 of 4. The heading is environmental management, and the question was, where are the conditions under environmental management agency? If you refer to the following page, page 3, those conditions are titled on-site sewage department, because on-site sewage is now a part of the environmental management agency. So that condition is the only condition as part of the environmental management agency.
Since I was the one who asked the question, I saw that it was on page 3 of 10. Is that it? Because
yes, at the
on
top.
page 2 of 4, I don't have a page 3 of 4. So I think that's why I was confused.
Okay.
I mean, I sort of read it further back.
Does anyone else?
I just want to make sure.
Does everyone else have an incomplete packet as well?
I just had 3 or 4. I knew it was a test to see if I was reading.
You read it. Very good.
Okay, I did. I read it. So on it's page 3 of 10.
There's a page 3 in that.
Got it. Okay, thank you.
Okay.
I appreciate that.
You're welcome.
Okay, are there any questions?
Just one question. The neighbors, I assume, or I'm certain, have been contacted, and they don't have a problem with these variances that are going to come?
They were contacted, and we did not receive a single comment.
Okay.
All right. Thank you. Are there any questions, comments from the public on this? I'll bring it back to the board.
Madam Chair, I would move the board adopt an ordinance to approve 2.9-32 zoning amendment for Copper Fire based upon the findings included in the staff report. Secondly, the board adopt the resolution to approve 2.9-32 conditional use permit for Copper Fire based upon the findings and conditions of approval included in the staff report. And thirdly, adopt the resolution to approve 2.9-32 setback variance for the Copper Fire District based upon the findings and conditions of approval included in the staff report.
I'll second that, and with that, I'd also like to compliment the planning department. There seems to be a lot on our agenda today. These have been catch-up things, but it's nice to be catching up. Good work.
Okay, with that editorial, I'll take the vote. All in favor?
Aye.
Opposed? Passes on a 4-0-1. Thank you. I'd like to move to item 9.
Good morning, Board. Lynette Norfolk, Treasurer Tax Collector. I'm here today with
Actually, Shirley Ryan did most of this work and then decided to head off to Hawaii, I think. But
you're going to see Shirley in Hawaii?
Yeah, well.
Her plane is passing mine.
Yeah, probably so.
Mine's following shortly after the election.
Yeah. Well, I tried to snag a seat with her, too, but that didn't work. But anyway, I'm here today regarding the Prop 1A receivables, and I have before you a huge packet that, hey, Marita said she went through everything on that last agenda item and caught the one page that's missing. I don't know if that still will hold here. Basically, under the state's plan to borrow 8% of the county property tax revenues, the impact to the county would be about $1,490,000 to the general fund. Revenue for roads would be reduced by $77,000 some odd. The airport would see a loss of $1,100, and county fire would lose about $29,000. The adoption of the Calaveras County fiscal year 9-10 final budget included revenue realized by the securitization of Prop 1A borrowing by the state. Why I'm here today is to have you pass that resolution and those documents in order to protect our monies, basically. You have the same packet I have. I can read the same thing. Do you have some questions that I might?
Are there any questions of Lynn? Are there any questions or comments from the public on this? Mr. Lawton, do you have any comments you wanted to make on this?
Not anything that would add substantially to what the Treasury Tax Committee is.
I might add one thing. I just pulled up the website, interestingly enough, today, and there are 1,359 cities, counties, and special districts who have, passed or have issued a notice of intent. Not all of those have passed their items that we have today, but.
When is the due date that cities, counties, and special districts have to submit their request?
We have to their request went in.
The request was in.
All the paperwork needs to be in by November 6th. Okay. And I'm interpreting that as in the office, and I'm prepared to go take it if need be. Whatever, we'll get it in there. Okay. They recommend from the office that people try to do it prior to that time, or at least make sure it's in there. In the mail doesn't really seem to count.
Right. For those special districts in Calaveras, do you have a list of those special districts who have signed up their intent?
Good question. The auditors, if I can find it here, Linda Churches, who also happens to be on a beach, I think, somewhere.
There's something wrong with this.
There's something wrong with me, I guess, that I'm not there. She presented a list, or her office presented a list that told all the special districts and what their impact on the Prop 1A estimate is for the affected agencies. She also sent a letter, or a memo, I should say, along with the August reports, the September reports, and I believe just recently as well another letter went out, as well as one I did to all the districts, reminding them to, get with the program if they're going to, basically, and just say they have to do their own, essentially, because our umbrella only includes general fund, roads, county fire, and the airport.
Okay, I just want to make sure none of them lose out if that was their intent. But
I see some have filed. Some are on this list already, and some have filed as well.
Okay.
So,
all right, thank you. I'm going to bring this back to the board. If there's no discussion.
I'll move that we adopt the resolution approving form and authorizing the execution and delivery of a purchase and sale agreement and related documents with respect to the sale of the seller's Proposition 1A receivable from the state, and directing and authorizing certain other actions in connection therewith.
Is there a second?
Included in this packet.
Thank you for reading all of that.
Yeah.
I'll second.
You sure?
Yes.
Okay. I want to remind the board what we designated with Mr. Lawton's recommendation that we do with the money. All in favor?
Aye.
Opposed? Passes on a 401.
Are you sure?
I am sure.
Thank you.
Okay, item 10 has been moved out. I'm going to move to item 11.
Item 11.
Lynn.
It's my item.
It's coming from county council.
I know it is, but I thought she has the right, she should be here. Lynn, the next item is on education for you. If I thought you might want to be in here, I know your position.
Thank you. I'll sit here.
Okay. I'm sorry. Thank you. Mr. Jones.
10, I'm sorry, I misunderstood.
10 has been moved out to November 3.
If you adopt this ordinance, you impose a continuing education requirement on the next holder of the Office of Treasurer or Tax Collector. It won't affect the current holder of that office.
Okay.
This is the introduction of the ordinance, and it's pretty straightforward otherwise. The continuing education requirement comes in after the new office holder is elected and requires 48 hours of various described options of continuing education to be completed sometime before the end of their 4-year term.
Okay, thank you, Mr. Jones. Are there any questions of Mr. Jones?
No, we've discussed this quite thoroughly.
Are there any, Lynn, did you want to make any comments?
No.
Okay, thank you. Any comments from the board?
Are you sure?
I'm pretty sure.
Okay, I want to make a comment. I will not be voting for this. I think it's immature on the part of the board telling the elected official that they have to take advanced education. I mean, we have other people within this county that continually take education, which of course the board does not fund, whether it's for county council's office, planning, building, or for the treasurer. I think this is ludicrous that we are doing this, I think. And I voiced my opinion on what the key were the conditions for the position, not telling them, well, we're not going to put conditions, but you have to take training. That's foolish. So I will not be voting for this.
I have a question, and that is, if we impose continuing education requirements, are those outlined somewhere, Jim?
In the section.
There's a code section that
and it tells you exactly what that entails?
So it's already in the code.
Courses recognized by the State and National Association, accredited college or university, or the California Debt and Investment Advisory Commission. So there's a fairly lengthy...
My next question then is, if we do this and the elected person doesn't do it, does this automatically remove them from office, or what does this do?
That's a good question. The section says, after describing the requirements of the continuing education, that the willful or negligent failure of any county officer serving in the capacity of county treasurer, county tax collector, or county treasurer tax collector to comply with the requirements of this section shall be deemed a violation of this section. This section does not contain a sanction. I can only infer from that this would be the potential for public criticism by a grand jury, or possibly even a basis for removal from office. But there is no sanction. It just says, shall be deemed a violation of this section. There is no particular penalty associated with it. And I should also point out that this can be repealed by the Board of Supervisors at any time.
Like the clerk recorder, do we require, I mean, most of these departments have continuing education available to them, and I suspect most of them, go to the classes and take them, or seminars, or however they're presented. I don't know that necessarily you get a certificate or the like, and I guess my question is, other than the auditor, it's the only department since I've been here that we've ever had any requirements, and I was reluctant to do those, and I'm not sure there was a continuing education requirement with it. I think it was an accounting requirement or the like.
A CPA. A CPA requirement, I believe, on the auditor.
To stand for the election
Yes.
for the office.
That's not an after that.
Right.
Yeah,
we discussed this before. There are preconditions to run for the office, and then this is a continuing education requirement that would apply only after the person's elected.
You should have asked me if I had something more, Gary, or was I sure? I thought I was sure that I didn't want to say anymore because you know my position on this. I felt that the two elements that I brought to you, both on the 22nd of September and the 6th of October, explained my position that the two elements should go together because basically the majority of counties that I've talked to, that's how their boards have adopted them. This educational requirement is something that my particular association through the state does have certificates, and they track the attendance, the continuing education units that you have. I'm sure there are hundreds of different ways to obtain those same educational requirements, perhaps not in quite as straightforward a way that my association does it. But I know that attendance at CDAC meetings, perhaps some of the attendance at the meetings where speakers speak of finance and taxation and things at CSAC and a lot of other organizations like that would also qualify. I would certainly put each of those in if requested. I've kept up my educational requirements even though it was not a requirement for the last 11 years I've been in office because it's prudent to do so. And I would hope that anyone holding this office would do that as well. But it'll be up to you to, make that designation. So that's probably all I need to say now. Thank you.
Is there any other comments from the board? Are there any comments from the public?
That's a good idea.
I think it's a really good idea. When I worked in the planning department here in the county, in 1981-82, I went to Cal and got my master's in land use planning because I thought it was a prudent thing to do. And I would certainly urge the board to approve this. Thank you. This is George Fry.
Are there any other public comments? I'll entertain a motion.
I'll make the motion to introduce the proposed ordinance to impose continuing education on the holder of the office of Treasurer Tax Collector and waive reading.
Is there a second? Dies for lack of a second. I'd like to move. All right, I'll open it up for another 10 seconds. Okay, thank you.
File in.
Sorry, Steve.
Unbelievable.
What, you want to make a comment?
Actually, I will make a comment, which is that we had a discussion in our last meeting on the topic in which we did not use words like immaturity, but talked about the Founding Fathers, their intent about open elections and not denying people access to running for office. And at the same time, because we had two measures in front of us, one that would have barred the bulk of the population of Calaveras from running for this office, and the other of which said, well, even if you don't have all the skills or alphabet soup after your name, there'd still be an obligation to get up and up to speed once in. At the time, the board majority was inclined toward the second, without trying to bar a lot of people from running for election. It appears that at this point there's no majority for either of the two measures, which I don't think will necessarily serve us well. But again, the citizens will make their decisions, and hopefully they'll be good.
Okay, thank you. I'd like to move to Item 12, a letter to the governor supporting the park and saving the trees at the Cal Fire Station in Altaville.
This you probably read about a little bit in the paper. It is in Altaville. It's the Cal Fire Station. They're going to redo it. And Marita's the author of the letter. I totally concur. And the reason is that there's plenty of open space there that they could design what they propose to do without the removal of any significant number of trees. It almost looks like it was designed to maximize the removal of trees. So others have looked at it. Senator Cox looked at it, and others, and I think we basically all agree. I think the board, we had a little drive-through when we went to lunch last Tuesday, and I think most of us would agree, or all of us would agree, that the design, they can do everything they need to do in an efficient manner with a design that would have a lot less impact on the trees on that facility, and that's the reason that, frankly, that I support the letter. It strikes me as being totally unnecessary, and so if other comments, that's fine. Otherwise, I'll make a motion to send the letter to the governor on behalf of the board.
I'll second the motion and also comment. I think just because you fight fire doesn't mean you have to clear-cut Altaville, and that there's really, it makes no aesthetic sense whatsoever. It's one of the nicest. It's a great entry into the town. There's not a lot of trees after that. Why not build in a flat area in the back of the trees, work around them, and again, as a basic principle of this kind of activity, work with the terrain you're given. It's actually pretty good as it is, and when we do our improvements, we should be at least aware of the possibilities of leaving a tree or two as we do this. So this property has all the possibilities of accomplishing that, hence my second.
Tim Follendorf, who's been the cheerleader on this, called last night and said he wants us to sign it and all, but to maybe hold off sending it till he finds out if we can go to the governor's office to deliver the letter from the county, from the City of Angels, and the petition. So I asked Madeline to to make all the copies, etc., and then to hold off sending it until Mr. Follendorf calls me, if that's okay with the board.
All right. And I'd also like to thank the chair for writing such a mature letter here.
Madam Chair.
Mature?
Yes, very mature. As
in? Okay, thank you.
It's short and to the point.
Short and to the point.
There's a point to be made there.
I'm not going to ask in public. Okay, may I have a motion? I have a second. All in favor? Aye. Passes on a 4-0-1 absent vote. Thank you. I'd like to move to item 13. Alternative conference. Mr. Fry brought this before the board a week ago. We have a copy of the letter from Supervisor Tryon going, and
Thank you, Howard.
What, are we having a show?
Yes.
Oh.
What is this now?
All right.
Well, do we need to dim the lights?
Yes. Yes. And you have to buy popcorn and sodas.
We passed a resolution for free popcorn for the board.
Yes, hot buttered popcorn.
Tom, you wrote this letter?
Where are the lights?
Which letter? Oh, is this the one I signed? And I want no comments on the maturity of the letter.
Like a very young person.
Good morning. Good morning, Charm. Marita. Good morning, rest of the supervisors. I'll let the DVD give you the information. Sound. Started over.
And is this what you're submitting,
Hold
Mr.
on.
Fry?
Yeah, hang on. Stop. Sound. Somebody shut the sound off.
Madeline, do you have this on? Okay. I need a change. Well, you don't put supervisor or district clerk because it's redundant. Yeah, that'd be good.
Turn it up a little bit.
Hi, everyone. My name is George Fry. I'm the chair of the Calaveras County Mental Health Board. And I have been on the Mental Health Board in Calaveras County for 15 years. I have been advocating for mental health clients since I retired as the state parole agent for the California Youth Authority. I also serve on the California Mental Health Planning Council. I've been a member of that council for 10 years. It has been my lifelong desire to bring the Alternatives Conference to Angels Camp, California. I would like to extend an invitation to all of you that are involved with the National Empowerment Center and Alternatives Conferences, and have the Alternative Conference for 2010 here at Angels Camp, a wonderful historic community.
Hi, this is Calaveras County Superintendent of Schools, John Brophy. I'd like to welcome you and invite you to attend the Alternatives Conference in beautiful Angels Camp in Calaveras County in 2010. The fall is a beautiful time of year here, and we think you'll have a great time. Our schools have a long history of cooperation with our behavioral health program and community agencies. Some of the artwork you see behind me was done by students in our schools. Please join us next year for the Alternatives Conference. We look forward to seeing you.
Well, Calaveras County is a great place to have a conference. We're warm and welcoming people in a small rural lifestyle and beautiful, beautiful surroundings. And we have all the amenities to attract and hold people's interest while they're attending the conference, such as award-winning wineries and restaurants and golfing and caving and many outdoor sports. And so I think we would be a great attraction for them, and they would really enjoy everything we have to offer. Calaveras County, the greatest place on earth. I'm Lisa DeMayo, and I'm the Executive Director of the Calaveras Visitors Bureau. And here at the Calaveras Visitors Bureau, we promote Calaveras County. Calaveras County Visitors Bureau, we work to bring tourism to Calaveras County. And this includes all areas, Valley Springs to Angels Camp to Arnold and beyond. We work with a lot of different groups to help make that happen. And we do a lot of advertising outside of the county, of course, and attend a lot of trade shows and various promotions to bring people here to see all the great offerings we have in Calaveras. Calaveras County, it's a wrap.
Hi, I'm Ray Malherbe. I'm the CEO at the Calaveras County Fair and Jumping Frog Jubilee. This fair is about 80 years old. We've been in the Mother Lode for a very long time, and we're happy to host one of the prominent events in the world with the Jumping Frog Jubilee. We're looking forward to the Alternatives Conference coming up in October of 2010, and we are hoping to see you all there. Here at the Calaveras County Fairgrounds, we can accommodate people in great numbers during our fair. We have attendance on any single day up to about 20,000. We've had concerts on our facility numbering 15,500, and we have plenty of buildings and other areas that are certainly usable, and we think we can fill your needs for the conference.
Hi, I'm Rita Downs. I'm the Director of Behavioral Health for Calaveras County. I just wanted to say that we would welcome having the Alternatives Conference, in Angels Camp, California in October of 2010. Thank you.
Hi, I'm Ann Forrest, and I am the chairman of the branding leadership team here in Angels Camp. I'm also a property owner here in downtown. And I hope that the Alternatives Conference will choose Angels Camp. This is such a great place. We're a base camp for mountain sports throughout the Sierras. We are halfway between Tahoe and Yosemite, and we have so many activities close by and within an hour from here. So we really hope you'll come and spend some time both before the conference and after.
I'm Bob Maneri. Welcome to Angels Camp. I'm the president of the Angels Camp Business Association. You think a business association in a little camping town like this that was started by the Angel Brothers back in 1848. That's when the gold rush was going on. They came here and started this beautiful town. The businesses in this town are wineries, shops, all different kind of antique stores, western wear, and gold mining shops. We also have other activities in the area for you to see, such as mountain cavern tours, zip lining, horseback riding, and we also have New Maloney's, which is a huge reservoir here where you can rent boats and go out on excursions in the day and see how the river was cut away and the water went through the caverns and made this beautiful country that we live in. So come to Angels Camp and enjoy what we enjoy 365 days a year. Thank you.
Good afternoon. I'm Michelle Lee with Central Sierra Lodging, which is Angels Inn Motel, Murphy's Inn Motel, and Murphy's Suites. I am a lifelong resident of Angels Camp in Calaveras County, and my family has been here for 4 generations. I would like to invite you to my hometown and stay with us here at the Angels Inn Motel. Our company has 164 rooms available to the traveling public. Throughout Calaveras County, we have 1,100 rooms, which comprise of timeshares, bed and breakfasts, and other hotels like ours. Whereas we live in a small town, serene environment, we, at all lodging locations, offer every amenity that you would expect to find in a larger city, especially being ADA compliant, as well as you will be greeted from our warm and friendly locals into our town. I'd like to personally invite you to Angels Camp, home of the world-famous Jumping Frog Jubilee, to spend your 2010 conference. We would love to have you. Can you edit that in?
That's it. That could end.
Is that your harmonica playing, George, in the background?
Yeah, that's mine. Okay, so I'm leaving on Thursday morning to go to Omaha for 4 days, and I'm going to be making this presentation at the Alternatives Conference. It looks like they're going to have close to 1,000 participants. So if we're fortunate enough, like I said in my letter, we're down to 2 locations now, Sacramento and Angels Camp. And I have another video that I'm going to be showing them there. It's the stark contrast between the Marriotts in downtown Sacramento and the asphalt jungle and the concrete and the lack of open space and what have you, and this video. So I think the choice is clear. What I'd like to do at this time is this trifold. I had about 5% participation in this. I just gave some ideas. But the person that put this trifold together, the person that I am fortunate enough to have as my webmaster, and she'll be my webmaster until the day I die, and that's Sharon Romano. Would you please stand up? She put this thing together. She did a great job. Thank you very much, Sharon. You've been so supportive. So I just wanted to run down a few things. You know, I out of my own pocket, I spent $1,400 for this trip, $340 for the video, $510 for printing, and Sharon in kind, $1,500. So it comes to $3,750 out of Sharon's and my pocket to bring this conference to Angels Camp and to Calaveras County. Not only is Angels Camp going to benefit from this, but folks are going to roam around. They're going to come for a week. This is their vacation. So they're either going to spend 3 days before the conference, 3 days after, 2 days before, that kind of thing. They're going to be here for 7 days. So they're going to see a lot of things. They're going to want to do a lot of things. And there's just the freedom to move about here. And, Angels Camp is my home, and that's the reason why I am running for city council. I want to bring economic development to the city, and this is one way of doing it. So I would really appreciate your support for a letter to Dr. Daniel Fisher, thank you, who's been a close friend of mine for over 6 years. I was born in Cambridge, Mass., and he lives in Cambridge, Mass., and we know a lot of the same people, although we never ran into each other before 6 years ago. So thank you very much for allowing me to take your time this morning to present this.
Thank you. I made some grammatical changes to the letter, which the clerk will retype and have Supervisor Tryon sign, unless the board doesn't want him to. Okay. All right. This letter will be ready for you early afternoon, George. Thank you.
Yeah, this doesn't take an action of the board. We'd already committed to this.
Yeah. All right. I'd like to move to item 14. I'm sorry. Yes, sir. Could you please come up and identify yourself? I apologize.
I'm Dr. Jim Morrissey. I'm a landowner here. And I think it was a wonderful video. There's one place they may have emphasized, I don't know what the mix is in terms of men and women, but they may try to appeal to the various sexes in the sense that we have some great golf courses here, very, very close. And there are a lot of things that women can do. I think you might try and push that a little harder if that's going to make a difference. Thank you.
Good. Thank you. Any other public comments before Supervisor Tryon signs this? All right. Can we move to item 14, please? This was a letter of support that the board agreed to a week ago. The letter has been written and it's been signed by Supervisor Thomas, who is probably in the air as we speak, but for the record, we do need to make a motion on this letter.
So moved.
Second.
All in favor? Aye. You're an aye?
I'm an aye.
An aye. Passes on a 401. Thank you. I'd like to move to item 15, correspondence reports, etc., from the board. Mr. Tuffanelli.
I have nothing to report other than I am flying to Hawaii after today's meeting.
Well, I think we should call an emergency meeting for tomorrow.
On what matter?
I don't know. We'll think of something.
Mr. Walensky.
Something in your district.
I'd like to report that I wish I was going to Hawaii. But I have only one board-appointed assignment this week, which is tomorrow going to the Webposium sponsored by the Sierra Nevada Conservancy, discussing the efforts to build sustainable economies in the Sierra.
Where is that, Steve?
That's up at Tahoe, and it's just a day.
Okay. All right. Tom?
I do not have anything to report to the board today, Madam Chair.
Okay. I have a 3 o'clock meeting in Mr. Lawton's office regarding the jail, Fish and Game Commission this week. hopefully, if I get the chance, depends on Fish and Game, I will go to the Calaveras Humane Society kickoff fundraiser at the Bank of Stockton tomorrow night. The Calaveras Humane Societies will be opening their doors tomorrow to their thrift store. And I have what was it that I asked you to, Treasury Oversight Committee this week at 9 a.m. at the library. And I'm not going to be able to attend. If someone could attend for me, which means Gary can't, so Steve or Tom get the pleasure. And if you can't, I mean, I can let Lynn know.
What time was that?
9 a.m. at the library in the back room.
Tomorrow, you're saying?
Okay, I mean, if you can't.
You're talking about tomorrow, not Thursday. Right.
Thursday.
I'm taking my daughter to the airport, so I won't
Okay, well.
be here.
All right, I'll just let Lynn know.
But
maybe I'll send Madeline. She can go, or Karen Barney.
There you go.
That's
that
okay.
Would be well represented.
I mean, I represent the board on Treasury Oversight, and Lynn does send the board members copies of her report. And okay, thank you, Mr. Lawton.
Thank you, Madam Chair. Your department heads held their second strategic planning session yesterday, and we will be bringing a draft strategic plan to the board at its December 1st meeting for your consideration, discussions, addition, subtraction, as you wish, and that will be the only item on the agenda for December 1st. So we're planning a full day of discussion. Department heads will be available, of course, to assist the board in their deliberations. I guess that is, and a reminder that we'll be bringing an item to the board, I think at the next meeting, to cancel the scheduled board meeting for November 17th. That falls during CSAC. So that's a reminder that we expect there'll be probably a quorum of the board either absent or unavailable for that week. So, and it's in keeping with previous years.
Okay. Mr. Lawton, on the first, for the strategic plan, we're still going to have a regular the board meeting, and that will have public comment.
Exactly. It will be the sole item on the agenda for a regular board meeting. So it will be open to the public. It will be, we will open it with public comment, and then the board will take up discussion and deliberation on the strategic plan.
Okay. Thank you, Mr. Jones.
Nothing.
Okay. This board stands in recess, and we'll be moving into a closed session.